Good morning, everyone, and welcome to today's webinar. We are delighted to have you to join us and unpack this important and timely topic, what the recent employment equity decisions means for the TES service providers and your clients. A special welcome to our guest speaker, John, whose expertise and insights will guide us throughout the implications of these changes, and your presence and greatness that you add value to this webinar. We are really looking forward to learning more about the employment equity today. To all the attendees, thank you for making the time to be here today, and how the employment equity developments will affect not only the TES providers yourself, but also your clients and to businesses that you serve. The understanding and the practical impact is key so that you can navigate the way forward with confidence and compliance. We encourage you to engage and ask questions and share your perspectives throughout the webinar. Please feel free to raise your hands and engage. John is here to assist us to unpack this. Together we can explore what this means in our industry and how to best prepare for the changes ahead. With that, let's get started. John, I'm handing over to you.
Thank you, Lisa, and good morning, everyone. Thank you, Krista, also for setting this up. A very, very warm welcome to you. And as Lisa said, it's definitely a very timeous webinar. Maybe we should have had it last month, but it's all good and we can get stuck into it. I'm just going to pull up my slide deck, and as was said, please feel free to engage. You're welcome to post in the chat box. Alternatively, you are welcome to wait till the end, I think, and then you can open up through Lisa for Q&A. Now, colleagues, the truth of the matter is the employment equity amendments have got incredible impacts on organizations and the people in organizations across many, many dimensions. And what I'm going to do today, and I'm not sure how long it's going to take, I don't think it'll take too long, but I want to just impress on you during the course of this session to please take note of the legal provisions in respect of TESs and how they stack up in the context of the Employment Equity Act. And the reason I'm emphasizing that, colleagues, is my experience in the workplace with your clients is that there's a huge amount of confusion and probably a huge amount of non-compliance. So I want you to first of all look at what we're going to discuss today with a compliance lens. Let's be focused on what the law requires rather than what we think the law should be saying, because sometimes the legal provisions are not very clear or they don't make common sense. So that's the first aspect. The second aspect is I want you to try and identify opportunities for you to use employment equity as a lever to grow your organization, to get closer to your clients, and to help them manage significant risk over the next 5 years. So that's really what I'm hoping to achieve today, is really those two dimensions. And we will then open up for Q&A. The truth of the matter is the impact of non-compliance is significant. But colleagues, let's get stuck into it. I'm going to be covering those two dimensions, firstly by just talking about unfair discrimination. Unfair discrimination, colleagues, is something that we think we are absolutely on top of, but I'm hoping to demonstrate to you that unfair discrimination has got a massive potential risk for you and for your client. And embedded within that is the issue of harassment. The next thing is affirmative action. Of course, the second point talks to the whole compliance of designated employers, who are obviously companies employing 50 or more employees. And the question there, of course, is how do you determine whether or not someone employs 50 or more employees when they use a TES? who reports on whom and what other obligations are there. And then the third one is risk and liability management. I'm going to touch on certain potential safeguards that you could look at writing into your service level agreements or into your commercial agreements, because you'll see that there's often a joint or several liability embedded within the particular penalties that can be imposed if you don't comply with the Employment Equity Act. And then I'm going to end off by just talking about what I believe are wonderful opportunities, colleagues, for you to really get under the skin of your clients. I've been saying for a number of months that we are in for a labor market bloodbath. I've got no doubt about that. And some people have said they don't agree and that I'm exaggerating it. But yesterday, my wife sent me a link to, I think it was a News 24 article, and it said exactly that. We're in for a labor market bloodbath because there are massive retrenchments. We see retrenchments taking place now at Ford, 490 odd people. We see Goodyear closed down in Uitenhage. 2 or 3 years before that, Contitech also closed down. Mercedes-Benz retrenched 750 people 2 years ago. We see ArcelorMittal busy retrenching. We see operating models of massive organizations undergoing transformation. If you take a look at ShopRite Checkers, you see how the operating model has evolved largely to last mile delivery and platform workers and e-commerce. So, colleagues, the point that I'm trying to make is this is the environment where you need to co-design and collaborate with your clients. You need to go and understand their pain, and you need to try and see how you can assist them, not only as a TES, but also as a functional outsourcing organization, as an employer of record, maybe automating processes, recruitment process outsourcing. Colleagues, this is a time you've got to be ahead of the curve and know more than your clients do, or else they don't need you. Let's just touch on the litigation status. Well, the DA litigation is continuing. They have followed a traditional legislative process, and of course, the High Court hearing was completed, and we are waiting for judgment in respect of that. So the High Court's judgment, we are waiting. The DA is challenging the constitutionality of Section 15, capital A, which of course is the ministerial targets. And they are saying that those targets are perpetuating imbalances and discrimination along the lines of race and gender. We then have the failed urgent interdict by Sakelicha and Niasa. 28th of last month, 28th of August, the Gauteng High Court dismissed the application by Sakelicha and Niasa. It was an urgent application, and the High Court said that they did not see any problem with what was happening on the face of it. They said that the department proved that they were consulting on employment equity as far back as 2019 on the targets. They said that the Minister of Employment and Labour had followed due process in gazetting the 15th of April targets this year and the regulations. And they said that there was no obvious constitutional infringement that they could see. So Sakelicha and Niasa have now announced that they are going to probably appeal to the Constitutional Court, and we will have to see what the outcome of that would be. We then have Solidarity, and colleagues, you will remember that Solidarity, they took the Department of Employment and Labour all the way to the ILO in Geneva. On the world stage, they accused government of breaching the constitution of South Africa, and the ILO then said, well, go back to South Africa and go and resolve the dispute yourselves. And you'll remember a settlement agreement was reached between Solidarity and the department. That settlement agreement included certain clauses that Solidarity are saying are not in the final regulations. So that contempt case, the first part has been heard, and the court has found that there are potential grounds for contempt of court that the minister has omitted to include certain provisions in the regulations. We're now waiting for the second round, and we will see what the outcome of that is. What I can tell you is that if there are any omissions, it will not nullify the targets or the regulations. They will just order that those provisions be included. And those provisions, colleagues, are focused mainly on the fact that the economically active population should not be the only factor determining the targets, that there should be skills and other circumstances that should be taken into account. So, by all accounts, thus far, it's all systems go. And of course, the 1st of September came, and the 1st of September required organizations to be fully compliant. We've had a number of companies approach us already who have been subjected to DG reviews even since the 1st of September. So the inspectorate are definitely upping their frequency of inspections. They're quite robust. I almost said aggressive, but for now I'll say robust. And you've just got to make sure that you are compliant and that your clients are compliant. And I think that's what differentiates today's discussion from any other discussion on employment equity, because what you do affects not only your business, but that of the client. And what the client does affects not only the client's business, but also yours. So this is an area where you're going to have to get a lot closer to your clients. So colleagues, let's start off with unfair discrimination. You'll all be familiar with Chapter 2 of the Employment Equity Act. And Chapter 2 is on the screen, so I'm not going to read through it. I'm just going to highlight certain key features of Chapter 2 on unfair discrimination, because on the next slide, we're going to explain to you the risks and the opportunities embedded within this. So the first thing, colleagues, that I want you to take note of is that unfair discrimination is based on around 26 prohibited grounds: race, gender, sex, sexual orientation, age, etc. So there are a number of grounds that could potentially result in you being found or your client being found to be discriminating unfairly. Then I want you to look at the third bullet point, that harassment is a form of unfair discrimination. And as you know, harassment has actually been contained and codified in a code of good practice on the prevention and elimination of harassment at the workplace, which has got a significant impact on you and your clients. The fourth area I want to raise in the unfair discrimination dimension is that the terms and conditions of employment between employees of the same employer performing the same or substantially the same work or work of equal value is unfair discrimination if it is not justified. So I want you to think for a moment. You've got temporary employees, your temporary assignees. You're placing them on your client's premises or to work for your client. And we're going to see just now, after 3 months, from an employment equity point of view, not only the LRA, but from an employment equity point of view, irrespective of the earnings threshold, under the Employment Equity Act, they're deemed to be employees of the client. So that means that when you compare your temporary assignees' terms and conditions, which includes remuneration, leave, sick leave, benefits, incentives, etc., and you compare your client's staff complement doing the same job, you've got to be very, very careful to ensure that you've aligned that. not only under this Act, under the Employment Equity Act, but as we all know, under the Labour Relations Act, Section 198, capital A, and obviously B and D. So one of the big challenges you're going to be facing is if ever you are found to be discriminating on an arbitrary ground, potentially between your client's staff earnings and your staff earnings, I think you may be exposed to allegations of unfair discrimination on arbitrary grounds. But we'll talk about that later on. The question is, how do we know if something is unfair discrimination? Well, if you look at the labor courts, they approach that question on the three grounds to the right. Now, I want you to think of what you do with your clients. Your client says, I need pickers, packers, artisans, millwrights, fitters, data capturers, whatever it is. Your client gives you a job order, and you need to fulfill this order, and you need to ensure that during recruitment, during selection, during assessment, during payment and remuneration, terms of employment, you need to ensure that you are discriminating fairly. So let's see what the determining questions are to see if you are discriminating fairly. The first one is differential treatment. So one of your assignees comes to you and says that they are a Seventh-day Adventist. They cannot work from sunset on a Friday to sunset on a Saturday. Therefore, they're not available for overtime work, just as an example. So now what happens is you say to them, listen, the contract requires you to work over weekends when we need you to do that and overtime. So what are you doing? You're now maybe taking disciplinary action, or you dealing with it as incapacity. I don't know. But whatever it is, you're treating them differently. Is it on a prohibited ground? Well, of course, on the left-hand side, we see religion is one of the grounds. So therefore, it's discrimination. The question is it fair discrimination? And fair discrimination, as you can see in the second bullet point, is it says it's not unfair to take affirmative action measures consistent with the purpose of this act or to use inherent requirements of a job. So that's the third one. So you would have to prove that you tried to accommodate this person because of their religious observations. You looked at all the alternatives, but ultimately you had no option to dismiss because of inherent job requirements. That would be how a court would approach discrimination. Now, remember, colleagues, the reason I'm talking about unfair discrimination is that the amendments to the Employment Equity Act, if you look at the right-hand side, are very, very clear on the impact of getting this wrong. Now, Section 53 of the Employment Equity Amendment Act says that a compliance certificate will not be issued if you are found guilty of unfair discrimination, including harassment, in the 12 months before the employment equity reporting period. In other words, if we use this year as an example, if you were a company that ended up at the CCMA or the Labour Court between 1 January this year and now, and you were found guilty of unfair discrimination or harassment or not taking preventative action, we'll get to that in a minute, you could lose and will lose your certificate of compliance. It's not just about the numerical targets, it's also conditional about not being found guilty in the preceding 12-month period. And I want you to think about not just yourself, but I want you to think about the impact on your client. Imagine if what you do results in your client losing their certificate of compliance. But I'm going to get to that in a minute. So Section 53 we've discussed. And then we also have the Code of Good Practice on the prevention and elimination of harassment. Now that requires firstly, that you have a harassment policy and procedure. Secondly, that you're required to do harassment awareness training. And thirdly, you need to do a harassment risk assessment. Now, you'll say, John, who said? Is this just something that you've come up with? No, colleagues. There are two sources of information that will justify this. The first one is you've got to understand that the Code of Good Practice specifically, look at paragraph 8.1 from the Code of Good Practice. I've quoted it. Employers are under obligation in terms of Section 60 of the Employment Equity Act. Now, Section 60 talks about vicarious liability. So if one of your temporary assignees, right, if one of your temporary assignees commits harassment, let's say like some recent cases, a male employee slaps a female employee on your client site on the buttocks, okay, that's sexual harassment. So what would happen is that female employee will refer you to the CCMA and maybe the Labour Court, and you would have to then prove under paragraph 8.1 and section 60 that you took proactive and remedial steps to prevent harassment. Then it says this includes an assessment of the risk of harassment that employees are exposed to while performing their duties as far as is reasonably possible. In other words, if you land up in the Labour Court, firstly, you'll see on the next slide, your client and you will probably both have to appear at the CCMA or the Labour Court. The second thing is you would have to prove that you have taken reasonable steps, proactive steps, which includes demonstrating you have a policy, zero tolerance policy, you've done awareness training for your temporary assignees before they were placed, and that you have done a harassment risk assessment, because harassment looks different in a mine compared to a warehouse, compared to a call center, compared to a hospital. So, colleagues, this is a very, very serious matter, Chapter 2. And people are so fixated on the targets, they forget about the issue of human conduct. So let's take a look at what the law says about, specifically about Chapter 2 and unfair discrimination, as well as Chapter 3. But let's look at Chapter 2 for now. Look at Section 60 on the left-hand side. I want you to look at subsection 2. The employer must consult all relevant parties and take the necessary steps to eliminate the alleged conduct. So if ever there is harassment, you've got to react immediately, and you've got to take necessary steps to consult the victim, the alleged perpetrator, and you've got to take it through to its conclusion. Then it says, under subsection 4, it says, an employer is not liable for the conduct of an employee. So let's say one of your TS assignees, as I said, smacked a female employee on the buttocks when she walked past him. It says you as the employer, but also potentially your client, will not be held liable if it can prove it did all that was reasonably practicable to ensure the employee would not act in contravention. In other words, it means you will have to demonstrate to the commissioner or to the judge in the Labour Court that you've got a zero tolerance policy, it was given to the employee, that you did awareness training, and you've done an harassment risk assessment. Very, very, very important, colleagues. And if you cannot prove that, you as the employer, and maybe even your client, will be found vicariously liable for the acts of your TS assignees. So let's go and see, now that we've established the liability for unfair discrimination and harassment, vicarious liability, for example, let's see what section 57 says. And this is the most important slide and section of this whole discussion today in my mind. Let's go to section 57, subsection 2, first of all. It says, where a temporary employment service on the express or implied instructions of a client commits an act of unfair discrimination, both the TES and the client are jointly and severally liable. So what it says in section 57, subsection 2, it says that if you as a TES are found to be acting on a discriminatory instruction of the client, then both of you could be liable jointly or severally liable. In other words, a client says to you, I only want men in the warehouse because you got to be strong. A client says to you, don't worry about this harassment issue. I'm not going to worry about it. Just take that woman who's complaining about harassment off this particular site. Or the client says to you, these are the job profile requirements, but they are unfair discriminatory. You see, colleagues, you and your clients could both be implicated. If you cannot prove you've taken these steps as a TES, you'll be jointly liable and you could lose your certificate of compliance and potentially your client could lose their certificate of compliance if you are found guilty in the 12 months preceding the reporting period. Now I want to go to section 57, subsection 1. This is a massive concern, colleagues. Now let's read what the law says. And I always make a very controversial statement, but I'm going to make it in any case. You know, if it says, thou shalt not commit adultery, and it's written plainly and clearly, then it means you shouldn't commit adultery, right? Because even if you get lucky one night, don't do it, right? Because your amygdala hijacks your rational thinking. Now, I'm using that as a symbolic example of what I'm about to read for you. If Section 57 of the Employment Equity Act says, for purposes of Chapter 3 of this Act, okay, Chapter 3, a person whose services have been procured for or provided to a client, that's what you do as a TS, right? You procure people, you provide them to a client by a temporary employment service, is deemed to be the employee of the client where that person's employment with the client is of indefinite duration or for a period of 3 months or longer. So let's unpack this. The first thing is I want to highlight that the deeming provision under this Act, which is the Employment Equity Act, after 3 months or indefinite employment, the deeming provision is not linked to the earnings threshold like the LRA is in terms of deeming. Whether you place an MD of a company or whether you place a general worker of a company, under the Employment Equity Act, after 3 months, they deemed to be the employees of the client for purposes of Chapter 3. It says for a period of 3 months or longer. In other words, in the new amended employment equity world, the 31st of August becomes the cutoff. The 31st of August, because from 1 September 2025 to 31 August 2030, and every year on that basis, your plans and your clients' employment equity plans have to be structured. So come the 31st of August, which is just passed, that is the cutoff in determining a number of things, whether or not, firstly, you are a designated employer of 50 or more, or whether your client is a designated employer of 50 or more, because some of your clients think they're really clever. So they'll only have 40 permanent staff, but they'll use you for another 40. But those other 40 that they get through you as a TES are there for more than 3 months. So come the 31st of August, guess what? Your client's actually got 80 heads and is a designated employer. I didn't say that. Chapter 3 of this Act says that, and I'm going to go into detail in that regard. Then I get people saying, what about learnerships? Surely they're temporary because they're only there for 12 months. No. Which part of for a period of 3 months or longer don't you understand? I'm not talking to you, I'm just talking in general. You know, they don't say here unless it's a learnership, unless it's yes for youth, unless it's a fixed term contract. They don't care. They're saying come 31st of August, whoever you're placing on your client side of more than 3 months is deemed to be the employee of the client. So let's see what chapter 3 says, because it says for purposes of chapter 3. So now let's go and look at chapter 3. I've literally copied and pasted it. So if you look at the left-hand side of the slide, chapter 3 covers, let me go through some of the key features. Chapter 3 covers affirmative action measures. You say, John, do our temporary employees on our clients' sites qualify for affirmative action measures under the client's dispensation? The answer is yes. Consultation. What do you mean, John, after 3 months? Does our temporary employees of more than 3 months, do they fall within the client's jurisdiction for consultation? Should the client's employment equity committee look out for our temporary assignees of more than 3 months? The answer is yes. In fact, in my view, the client should have a standard agenda item on their meeting called TES, and you need to go and share information on recruitment, promotions, training, terminations, and so on and so forth. Then look at section 19. When you do a workforce profile analysis, when the client does the analysis, must they include your more than 3 months temps? The answer is yes. At the 31st of August, whoever's been on the client's premises for more than 3 months and assigned to that client, the client's got to include them in section 19, the analysis, section 20, the employment equity plan, and in section 21 and 23, when they report every year on the EEA2 and the EEA4. And that's why I also said earlier, you've got to be careful on equal pay for work of equal value, because if you're placing artisans under the skilled technical sector or occupational level, and your client's got people doing the same jobs and they analyze it and your people are earning 20, 30% less than your clients based on their remuneration, you're going to have a problem. Your client's going to have a problem. So, colleagues, for purposes of chapter 3 is a very loaded statement. And I'm asking you a number of questions. So, question 1, have you, as at 31st August 2025, given your clients a list of all the temporary assignees, their race, their gender, their occupational level, who've been placed there for more than 3 months come the 31st of August 2025? That's the first question. Because your client has to include them in its activities in chapter 3. Second question I want to ask you, have you reported in your employment equity report the less than 3 months TES assignees? In other words, so that there's no duplication. The client reports on more, you report on the less than 3 months. Question number 3, have you got a harassment policy? Do you do harassment awareness sessions? And have you done harassment risk assessments for your temporary assignees? If your answer to any of those is no, both you and your clients are facing serious, serious risk. You could be fined up to 2% of your annual turnover, or your client could be fined up to 2% of their annual turnover. And if you've got big clients, some big retailers, 2% of their turnover is 4 billion rand. Not 4 million, 4 billion rand. So I am making a meal of this because it's critically important. So what does it mean? If you look, for example, at this workforce profile, the client reports on more than 3 months TS assignees across these levels in terms of section 57, subsection 1. You report on the less than 3 months assignees come the 31st of August every year. Very, very important. Now, let me go back to this word temporary. So I went to the EEA 2 and I cut this and pasted it in here. And look at paragraph I. The heading is instructions. Paragraph I says, temporary employees are those employees employed for less than 3 months. It doesn't say unless it's a learnership, unless it's an internship, unless it's a fixed term contract, unless it's a yes for youth. No, doesn't matter. Even if they're on a fixed term contract for 4 months, they get reported above the line by your client. Very important. So what are the liabilities and risks if you get this wrong? Well, as I indicated to you, colleagues, you can get fined up to 2% of your annual turnover for non-compliance with Chapter 3. You can get Labour Court awards against you for unfair discrimination and lose your your certificate of compliance. You can be found non-compliant in terms of the Code of Good Practice on harassment, and you can be vicariously liable. So this is a massive risk for both you and your client. But it can also be an opportunity if you can go to your client and say to your client, come the 31st of August, here's the report. Here's proof that we put all our employees through harassment awareness training. Here's our policy. Here we do a quarterly or biannual harassment risk assessment, etc., etc. Your client will say, well done. Thank you. You're on top of your game. So the great opportunity for you as TES, and I'm almost finished, and we can open up for Q&A. The great opportunity for TES, in my view, colleagues, is you've got potentially 29,000 designated employers. So look at these 18 sectors. All of you, you've probably got most of your clients are probably in manufacturing, probably in transport and storage, retail and wholesale, construction. But you can take a look and see where most of your clients fall. You can then go and proactively engage with your clients who are designated employers. This was the number at the end of 2024. So, there's 7.7 million employees placed by these 29,000 employers. And it's an opportunity to go and sit in front of your client. Now, let's say, for example, your client is in water supply, sewerage, and waste management. I just chose one of the 18 sectors. You can go and demonstrate to your client what the sector looks like. And you can say, in this sector, these are the trends. And you, client, probably have got similar trends. Look there. African female, major underrepresentation in terms of top, senior, middle, junior management, and semi-skilled in the waste, water supply, waste management sector. And say to your client, the minister's targets at semi-skilled are 33%, sorry, are 37.5%. You only on 33. How can we help you? You see, you can go and you can get under their skin and you can say to them, listen, this is your deficit. These are the shortfalls. This is how we can help you. We can use probation. We can use working interviews. We can use the TES model as it stands. We can supplemented with learnerships and with Yes for Youth, and we can use ETI and Section 12H tax breaks and whatever it is. But colleagues, your clients have all put together a 5-year plan. And if they share that plan with you and you can see how you can help build a talent pipeline, etc. So these are just some of the value added services that I believe you can look at offering to your clients to rather than get them to leave you because they say, well, we're liable in any case, why don't we just do it ourselves? To rather go to them and proactively say, we have a deviation protocol. So in other words, if your client's employment equity plan shows that, as is the case with waste, that they're underrepresented on African female at most levels, when you do their recruitment, you can keep a portfolio of evidence and you can say, well, we advertised, this is the response, these are the males, these are the females, etc. You can help build a portfolio to help your client justify deviations from the employment equity plan. You can build talent pipelines that are specifically aligned to your client's underrepresentation areas over the next 5 years. You can actually get annuity income. If you know, I've got a client, for example, who has about 500 resignations a year. Imagine if you can go to them and say, if we do X, Y, and Z, we can take 200 of these and build a pipeline for you so you don't have to wait. And that pipeline can have the right race and gender and skills mix. What about harassment risk assessments? Don't just do it for yourself, offer it to your client. Give your client reports on how temps and your client's employees maybe benchmark against each other. Colleagues, the other issue is, remember, the labour law review is busy going through Parliament. And one of the big changes is that during probation, you're going to be able to dismiss people for any reason other than their prohibited grounds and race and gender. So I think you've got to start gearing up and talking to your clients about how you can leverage probation for working interviews so that if someone's not fitting in, they don't have the skills, they don't have the culture and motivational fit, that's easier to terminate their services in the first 3 to 6 months. Why not support your client? Maybe even offer to facilitate their EE committee, or at least to report back every quarter on all the requirements, all the data sets for the temporary assignees. Use learnerships, internships, bursaries, get innovative, look at new mechanisms and new models, just like Checkers 60. I see Checkers now have also got the smart trolley. We need to become the ShopRite Checkers of the retail and wholesale environments, colleagues. Education, training and development, micro learning, platform learning, access to learning is very important, especially for the soft skills. You can have all the talent and you can have all the knowledge and the skills, but if you've got the personality of a dead chicken, then you've got a problem. So let's start training our people on EQ and how to build strong, trusting relationships and how to be resilient and how to adapt through change. And I promise you it will change the entire workforce culture. Well, I'm going to end off with an example of how quickly you can get into trouble. This case was one of the cases that it's just so telling. And it just shows how people can get into trouble very quickly and not necessarily always mean it. But the problem is not how you mean it. The problem is how the other person perceives your conduct. So in this case, at Anglo American, there was a contractor called John Sefton, luckily not John Botha. I just want to confirm that. And John Sefton, he went to work and he had a lunch container. And obviously, I don't know who packed his lunch. Maybe he packed his own lunch. But his lunch box was so full, colleagues, that he actually had to put a strap around it. Anyway, the time came for him to eat his lunch. He unstrapped his lunch box. A female employee walks past him and he takes the strap and smacks the female employee on her buttocks. Even though he was a subcontractor, he was denied access to the mine and he was dismissed, and the female employee took exception to this. So John Sefton realized what he did. He apologized. He said it was a joke. It was a gesture. Sorry, I won't do it again. And the court said, not acceptable, because the person who's the recipient of this conduct's human dignity is undermined. Now, colleagues, if you can't prove that you have got the policy, the awareness training, the harassment risk assessment, and have dealt with it, both you and your client, in terms of Section 57, could find yourselves in hot water. The big challenge here, and I'm sure there are many of you sitting on this call today who haven't, let's call it, complied 100% with what I've spoken about under Chapter 2, discrimination and harassment, and Chapter 3. In fact, probably some of your clients have told you we're not interested in reporting on your temporary assignees. Colleagues, this is part of the change curve. You know, when we deal with this, there's shock, denial, frustration. Eventually, we get a bit depressed, but then we realize we better get with the program and we start digging our way and we start engaging and bargaining and seeing how we can institutionalize this within our environments. My strong recommendation is if you haven't done it, start dialogue with your clients. Sit with them, collaborate, let them know you want to cover them, let them know that you have their interests and your assignees' interests at heart. And then take it from there, colleagues, and start building very strong solutions and value propositions over the next 5 years. So, Lisa and Krista, with that, I'm going to hand back to you. I'm also going to have a quick look at the chat box to see if there are any questions. And I see there aren't any questions. So either I've done a good job or everyone's gone to sleep, or you're very shocked.
Well, John, we're going to wake them up just now. Thank you, John, so much for such a clear and insightful unpacking of what the recent employment equity dispensation means for the TES service providers as well as their clients. Obviously, it's dual, and especially for pointing out the unknown opportunities that we didn't know is available that lies within. It's a good reminder that even when it feels like a dark cloud is hanging over us again in the TS industry, that there's always a silver lining, and who knows, maybe even a bit of sunshine that can help us rise to the next level. Your expertise has really given us again clarity on both the challenges and the opportunities ahead. Now, we'd love to hear from you guys that's awake now. This is your chance to ask John those burning questions. So don't be shy. You can raise your hand or simply just pop a question in the chat. We'll work through it as many as we can. Think of it as your opportunity to keep John on his toes a little longer.
Lisa, I see 3 colleagues have posted in the chat box, if I may answer them. Mabutsetso
Fire away.
says, thank you. For purposes of the analysis, which is the EA12, and the EE plan, which is the EA13, do deemed employees have to be included on the TS or the client plan? They have to be included on the client plan. Simple, straightforward, Section 57. No debate around that because it says for purposes of Chapter 3. Chapter 3, as I indicated to you, covers that. It includes reporting, analysis, etc. So often people go and they say, well, it's just for the EA2. No ways. It's for the entire scope of Chapter 3. Very good question. Samantha, how we recommend harassment training, especially in your environment where you can't pull your assignees off work, etc. I would firstly recommend you have a video, maybe a 5-minute video that is really, really intense and compelling, maybe in 2 or 3 languages, and that people either have access to that video as part of their, or not access, they see it as part of their induction. Alternatively, you do an annual refresher and you send them a link and they've got to check it out. So Samantha, I think that's probably the most cost-effective way to do that. And then just send them the harassment policy and, the grievance policy, whatever, and cover yourself from that point of view. Phyllis, it's an absolute pleasure. Thank you. Any other questions or comments? You're welcome to raise your hands or type in the chat box. Lisa, I think that is it. Short and sweet.
Thank you, John. Thank you, everybody, for joining us then today and for being part of this important conversation. I can see, especially on the EEAs, I know from past experience that is definitely a huge misunderstanding between should the TES report, should the client report, and thank you for clarifying that for us as well. Well, Krista will definitely send out the slides and the recording shortly after the meeting during the course of today or tomorrow to you all. And I just want to ask, we're going to host two webinars, one in October and one in November. And we would really, really ask all our members to please attend. We will extend the extended invitation whereby you will be able to invite your clients, as that will be relevant to them as well. So please keep open your diaries for the dates that will be sending out by Krista and Kumu for the CEA, and see if you guys can please attend for us those webinars. It's going to be very, very insightful. And it will not be John that's going to host them. We've got a surprise presenter for you. So it's going to be a little bit of a fresh air as well. We're going to give John some time to take a rest. Thank you, everybody, for your time, and have a great day further.
Thank you, everyone. Goodbye, Lisa. Goodbye, colleagues.
Bye, John. Bye, everybody.